Yes. When we last left, we were discussing modern trends. Uh, Now it's looking at the constitutionality of drugs, just kind of as a segue, and then we'll talk about schedules. But basically, uh, there have been drugs that have been used in religious ceremonies for a long time, uh, and for the longest time it was a controlled it still is. It's still considered a controlled substance. But then we actually uh and it was applied, like, each state was allowed to, ban it or whatever. But then it took until 20 years ago, something like that, maybe even less than that, that the government finally said, okay, fine, we're going to make an exception for these because it's hallucinogens. The American Indian Religious Freedom Act basically says that peyote, which is the hallucinogen that Native Americans use for their ritual, um, is allowed to be used, but you have to be part of it. Only can be used as part of the religious ceremony. But this is opening the door for what I mentioned in the last video, where the um, there are other areas that are trying to exempt it, specifically cities. They're creating local ordinances and regulations or deregulations to say, hey, the hallucinogens aren't so bad. We started out with marijuana, and the next tier of that is probably going to be hallucinogens, where we start to see a lot of deregulation. I don't see it going much farther than that, um, in the sense of the control, because of this right here, the actual schedule. You see that the definition is kind of, I don't know how to put it. You look at the definition, it says, all right, well, I'll just take Schedule 1. Controlled substances that have no established medicinal usage, cannot be used safely, and have great potential for harm. And then they put marijuana in it, yet we're deregulating that. And on the surface, it seems asinine. Even below the surface, it seems somewhat asinine. And what it is you've got three things going on at the same time. You've got a medicinal chemical science thing. You've got a legal thing, lawyers and such. And then you've got just uh, public impression and public will, and they don't always coincide. And you'll see that a lot in the law. You'll get a group of people that don't like something, and then they'll try to convince the politicians and the lawyers, because, again, politicians don't have to be lawyers, to make changes that contradict or don't even coincide with medicinal and scientific evidence. A lot of times they don't even think about the same things. So, but that's what you'll see is, we have this definition of controlled substances that have no medicinal usage, cannot be used safely, and have great potential for harm. But then they don't look at the scientific evidence that marijuana has been used quite a bit. Hashish is a derivative of marijuana, similar to marijuana, and the oils from that have been used quite a bit. So you start looking at this, and I start to, oops, I went a little too far. I see that these ones here are the ones that we're attacking right now, because it says no medicinal purpose. Then you go here, highly potential for abuse. High potential for abuse. Well, yes, these ones do. But then they say there are some medicinal purposes, and that's true. Many people don't realize that cocaine has a medicinal purpose. It's actually a cauterizing agent. If you get a nosebleed, you'll and it's severe, they will actually put cocaine up your nose. Just, you're not supposed to snort it. They just put it up there and let it cauterize. So we start seeing that basically I always get the question of this when I'm teaching paramedics, when I'm teaching lawyers, everybody, this doesn't make sense. And I agree. Because you've got three different entities trying to do the same thing. You've got a group of people who have very little knowledge, but they think that, hey, this is not good. We don't like this. Then you have the group of people that are making the laws, and then you have the scientists who really don't have an opinion one way or the other. They're just laying out the facts, and these two don't like look at them, or maybe only partially look at them. Common in the legal system also. So drug offenses. There are a lot of drug offenses. Most states have three different tiers to their drug offense: a use, a possession, and a distribution. And then you may have a manufacturer. So really there's four, but the manufacturer usually comes with the distribution, but it may not be. That's the reason why we had to add that on, because some people would manufacture but not distribute. But what do you do with it? I mean, if you manufacture the drug, at some point you've got to give it away, or you've got to get it somewhere, because then it's just distributed. But then the people who are distributing don't manufacture. So we tried to cut the entire supply chain, basically. And that's really what you're looking at, is the supply chain: a user, a seller, a distributor, or a user, a possessor, a distributor slash seller, and somebody who makes it. So we're really eliminating the complete supply chain. And this did come about with that war on drugs, and it attacked the entire industry, because it's an underground industry. It attacked the entire underground industry of something that we have deemed to be a problem in society. So boom. And the same thing with like prostitution. You can't solicit a prostitute, and you can't be a prostitute. So we're cutting off the supply chain. What's possession? Possession is either, I have this is possessing, or I could use it, but it's not right here right now. That's the difference. Actual possession is, I got this. This is mine. I have possession of these. Where constructive possession is, well, that pen's right there. It's my pen, or it's a pen that I know I have active use for, or I could use it at any time, and it's within reach. That's constructive possession. It's accessible. In the sense of drugs, it's typically, I don't actually have to have it in my pocket, but it's in my car. Or better yet, we typically extend that to, if it's in the car, every person in the car has constructive possession of it. None of them will actually have it. It might be underneath the passenger seat. So nobody technically has possession of it, right? Because it's not in their hand. They're not grasping it. It's like, oh, that's my cocaine. And it's not in their pocket. So it's not on them. So we have expanded that out to the constructive possession of, it's within your dominion and control, therefore it is yours. And it's been used as a discouraging factor to say, look, don't get in a car with a guy that's got drugs, or, don't try to use that loophole. Is what it really originally was, for the loophole purposes. People were getting off charges when they had possession of drugs of some sort, but nobody actually had possession of the drugs. So what do? That's when we extended it out to the constructive possession. Most states require a knowing state of mind, meaning that they have the knowledge that it's there. And that's all it takes. Now, if you can prove that you didn't know it was there, that becomes a flip-flop. For example, it's your car, but your brother's driving it. The constructive possession is going to be yours. Right? It's just going to be there. If you know he was driving down the street, now this is kind of irrelevant, but I dealt with this more frequently. Driving down the street, he was your passenger smoking weed, and the little leftovers are stuck in your ashtray. You knew he had it. It's still constructive possession because you knew it was there, and you should have done something to eliminate. Every state allows suspect to be punished when there's proof that they willfully blinded themselves to actually knowledge of the illegal character. Basically, you can't turn a blind eye, and that's what, if you have enough circumstantial evidence to realize that you know or should have known, you're going to be on the hook for it. But like, you just got in the car, for example. That's the one that I was able to use successfully. They just picked my client up, and there was a brick of marijuana underneath his seat. But he had just gotten in the car. They were pulling out of his neighborhood because they went in, picked him up, and they left. He didn't know there was anything underneath the seat, and it held water. It floated. So there's that. You've got to be able to make that disconnect to the stuff, because this applies in any type of possessory situation. If it's possession of firearms, if it's possession of gun or drugs, whatever, you can have actual or constructive possession. So you get in a situation where there's a gun under your seat. You didn't actually touch it, but it's not supposed to be there. You're still on the hook. Irrelevance of amount, it just depends on the state. There's no minimum amount, but the more you have, the more you're going to get in trouble for it. In fact, you can, purely on volume, you can carry it enough to say, well, that's possession with intent to deliver. Because, we always try to do that. Oh, but it was for personal use, but it was 10 pounds. That's a lot of anything. But you can always try that, and it doesn't always hold water. But there's an amount, and it's based on statute and its weight. There is no minimum as long as there's a trace amount that it can be analyzed to determine that was the substance. Because what happens is you dump it. Now you may have had a ton of it, and you dumped all but enough for me to realize that you have it, but still enough. And that's what the relevance is. It only increases it. It doesn't negate it. You have to have all you have to have is enough to recognize that it's a substance. And possession with intent to deliver is usually an amount, but you can look at other things, scales. I don't know, with math, like actually having the stuff to make it. Anything that baggies, scales and baggies are kind of telltale. Stuff like that tends to say, oh, hey, wait a minute, I'm not just using it for myself. If I'm separating it out into little individual containers, that's telling me that I'm not just keeping it for myself, I'm giving it to other people too. So possession with intent to deliver, that's how you prove intent to deliver, other than the fact that you actually did. Volume's huge, and then the scales and all that fun stuff. And then actual delivery, that's how drug deals go down. You get a police officer to buy it from you. There it is. That's all you had to do, is you gave it to him. Money doesn't even have to exchange hands. Hey, I'll buy that ounce. All right, here, and you hand me that ounce, you get the nice little bracelets. They're special. And it doesn't have to be the real drug. That's another aspect of it. If you're trying to pass powdered sugar off as cocaine, but you tell me as the undercover officer that, hey, this is coke, man, this is the good stuff, and you hand it to me and tell me that it's coke, and you're trying to get me to believe this, that's all it takes, you're trying to get me to believe, that's okay. And it doesn't even have, it's, the appearance, whatever, anything that makes them, a reasonable person, believe that it's the substance. If you're passing it off, you don't actually have to have the actual substance if you're showing the intent to deliver, because you intended to deliver. Even if I gave you fake stuff, that's another one that comes up. You're involved in a drug bust, you got an undercover agent with you, and he gives you a brick of cornstarch, but you think it's cocaine, and you're passing it off and trying to sell it as cocaine because that's what you thought you bought from the undercover agent. He didn't give you cocaine, he gave you cornstarch. You thought it was, and you try to pass it off as cocaine, still delivery. Conspiracy is just when more than one person gets in on it. Just like, we talked about conspiracy a long time ago, galaxy far, far away. Conspiracy is anytime you're doing the drug act. Drug loitering is under scrutiny now because you've got to show something more tangible. And that's where your drug conspiracy or your drug loitering is, because loitering is a ticket. But when you add drug loitering, they usually make it a misdemeanor. And so if you're going to do that, you've got to show something more tangible. And that's why the Supreme Court has been very hesitant to allow drug loitering charges. There's a possibility that you're hanging around a certain location, because that's a drug deal. You're on a street corner, you're just kind of hanging out, and somebody comes up and knows who you are, and you just kind of exchange the drugs. Or you're hanging out in front of the liquor store, or whatever. You're usually hanging out. Well, they're trying to eliminate the process. We looked at the manufacture, the sale, the distribution, the use, possession, all that stuff of the drugs. We're even hanging on the process. We're trying to eliminate the things that go with the process in order to basically get rid of the drug trade. But these ones are a little bit more constitutionally unstable, shall we say. Drug transportation, simple as it sounds, you're a mule. Transporting drugs across state lines. Moving it from one point to another, that's all it takes. Really, that's it. You're just moving from one place to the other. Now, if it's statutory crime, it doesn't even have to be state lines. It can be from jurisdiction. It's defined in a statutory way of jurisdiction to jurisdiction. But in a federal way, you're crossing state lines. Going back to the term I used a lot, interstate commerce. If you ever take con law, you'll hear that crap a lot, because that's how the Supreme Court likes to get their hands in things, because you're affecting interstate commerce. That's the federal, because you're crossing state lines. But anytime you pass from one jurisdiction to another can be drug transportation. In fact, in some statutes, it doesn't even require jurisdictional issues. I could be transporting it from my warehouse to my van and still be considered transporting. So, you got to be careful of that. Now, cultivating marijuana is no longer illegal. Let me rephrase. It is not as illegal as it used to be. You can cultivate marijuana in Michigan with some parameters. That's really what it is there's some parameters. What you're dealing with is you can cultivate a certain amount. You can cultivate for certain purposes, because when we had only the medical marijuana statute, there was a lot more to it when it came to what amount per person. Like, if I were a provider, I could have so much for the number of people I could provide for, and I could have so many people I could provide for. And, now it's just a blanket number under the cultivation rule. You're not allowed to sell it without a license. So I can't just go out in my backyard and take my whole back 40 and lay out some marijuana plants and just start selling that like people do. You're a farmer farming corn. I'm just farming my marijuana. No, you don't have to have a farm license. You don't have to have a corn license, but you have to have a marijuana license in order to cultivate it, because they want to control and whatever. Another one is drug paraphernalia. It's a misdemeanor. One hits, bongs, all that stuff. Technically, anything that's used. So for heroin, any of the stuff used for heroin, there's all kinds of stuff that go along with heroin. The spoon and the what do you call it? The little I wish I could remember the name of it. It's just a piece of scouring pad that goes in there as a filter. All of that is considered drug paraphernalia, and most of the time it's a misdemeanor. Now, narcotics or drug addiction as a defense, it is not. we have, if you are being charged with use, you can defend with, I have an addiction. If you have the addiction, generally it's not an absolute defense. And that's because we're still, because I mean, if you're not trying to get treated, then you really have eliminated your defense. So it's 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 a it's always an issue. We use that as a defense, but it never completely negates it. So what ends up happening is we use it to get them treatment, and sometimes we get, because like that's why we have the drug courts. That's why we have all these alternative corrections issues, because the states are allowed to. States are free to punish sale, purchase, and possession of narcotics. Addiction to drugs is a disease, according to DSM, and it cannot be punished criminally under the Cruel and Unusual Punishment Clause, the Eighth Amendment to the U.S. Constitution. That's what they say, but there are cases upon cases that say, you know what, states can still punish. So we don't have it as an absolute defense. What typically happens is we send you to drug court, or we actually send you to a some sort of rehab as an alternative, and we hold your conviction in abeyance and all that fun stuff. Wheeler, defendant, admitted to living in the room where the drugs were found. Circumstantial evidence constructive possession. He knew it was there. You can't turn a blind eye. That's what that really boils down to. The Savelli case, blind eye. Jewel case, deliberate ignorance does not negate it. You know, you didn't look in that direction. Jones, trace amounts. Hey, trace amounts. There's no amount requirement. State versus Brown is not good law in Michigan. Intent to deliver is fact-based, and volume alone is not enough to prove intent. Yes, it is. That's not a Supreme Court case. That's it's a Ninth Circuit case. Michigan, if you're in the Sixth Circuit, it hasn't been overturned yet, and we've been doing that for a long time. A sack with individual baggies of marijuana, a big box of baggies are not enough to prove intent to deliver. Again, this is 1995, and that was the ninth. Sixth Circuit says, you know, all those put together, you put those together, volume alone is enough, because and I think that might be the difference, because Michigan law has that written into the statute, and the statute itself has not been overturned. Therefore, if you were just saying that, hey, possession with intent to deliver, going to do this, it must be fact-based to pass circuit court muster. Well, what'll happen is, if your statute specifically says that, then the statute has to be found unconstitutional, and ours has not. One must knowingly participate in drug operation, not simply be a customer for a conspiracy to occur. That's self-explanatory. You can't just be there to have a conspiracy, because you're looking at the manufacture and sale. The transaction is incomplete without you making the sale. That's correct. But the sale conspiracy requires together. Totality of the circumstances, I'll believe that drug sales were occurring, even without the drugs in their possession at the time the arrest for the drug loitering charge stands. Again, it's really kind of interesting how we're all over the board on these cases. We're very much all over the board because you have different perspectives on drugs, you have different perspectives on the type of drugs, and a lot of it does come down to what drug is it. If you have cocaine, there's a lot of places, cocaine and heroin are like totally verboten. So we treat those differently than, let's say they had an ounce of marijuana. If they had a pound of marijuana, going back to the case earlier, they had a pound of marijuana. Well, if you had a pound of marijuana, that could be personal use. That must have been a California case, because a pound of marijuana here is delivery. I mean, there's no two ways about it. In Michigan, that's a delivery charge. So, and it's really kind of funny because you look at this one here, United States v. Moore, acts of addiction such as possession are still punishable. Yet, did we or did we not say cannot be punished under the cruel and unusual clause just because you're addicted? Now, you're not punishing the addiction. I think that's the distinction I really want you to make. You're not punishing the addiction, you're punishing the behavior that results from the addiction. That's the important part. You're addicted, okay? You're high right now. I can't punish you for being high unless you do something stupid. You punch me, I punish you. You hit your wife, I punish you. That type of stuff, because that's the behavior. Because remember, I talk about I'm a behaviorist and I treat behavior. Yeah, but just because you're an addict, I can't punish you just for being an addict. And I think that's the distinction. And you've got to remember that I'm treating I'm punishing the behavior, not the fact that you're addicted. Very much a distinction. Now, alcohol. Alcohol is kind of interesting because alcohol has been around for a long time. People have been fermenting shit for a long time. We've been making alcohol for a long time, and we've been doing stuff with alcohol for a long time. It's been a big business. Yet we banned it for a while. And it still can be completely banned in local jurisdictions, and we don't care. It's really funny to go. My ex-wife lives in Kentucky, and I went down to visit my daughter, or take my daughter down to visit her. Or no, it was actually during COVID. I went down to visit my daughter, and I try to find a beer down there. It's you go. They call them dry counties. You have to go looking for a county that it's legal to sell alcohol. And then it's like, because in Michigan, you have beer and wine, and then liquor are two different categories that you have to. Beer and wine have one set of licenses, and then hard liquor is a different one. We have had a problem with liquor for the longest time. We still don't like it. We still try to regulate it. We still try to do things with it, yet it's become socially acceptable. For the most part, I mean, as long as you're not a total asshole, it's okay to get drunk. But we still tamper it a lot. In the 1800s, there was a lot of religious groups that are saying, liquor is bad, you can't have liquor. And so in 1843, Oregon just banned it. And a lot of the conservative states started doing it. And some of it was because of the different, like you had logging, both of them, Oregon and Maine. You had the logging industry, and the logging industry, people would come in off the line and be drunk off their ass and cause problems in town. Well, we didn't like that. So what did we do? We banned the alcohol instead of trying to tamper the behavior. And that's what you see is we are behaviorists. We treat behavior, but in what we've been trying to do is get rid of the source of the behavior. People get high on cocaine, go out and commit crimes, or we make the assumption. We've always made that assumption throughout our history is this causes this. We kind of pull out the human factor. The devil made him do it. The cocaine made him do it. The marijuana, the opioid, the alcohol, pick a thing. but it still boiled down to you voluntarily ingested this substance and you acted like an ass. So we got you in trouble. But what we're trying to do is eliminate that first. And that's where all these things come from. And so the late 1800s, we started prohibiting alcohol in different forms. Carrie Nation, the Women's Christian Temperance Union, and then the National Prohibition Party, the Anti-Saloon League. I can just imagine those guys having a real party. Then in 1880, the state of Kansas put it right into their state constitution. We do not want alcohol whatsoever. And by 1917, 13 states said, we're not going to have alcohol and we're going to prohibit it, be it not necessarily in their constitution, but we're going to say, look, I'm going to make laws forbidding alcohol. And those are still legal today. It's just not a U.S. thing. We still have states that limit the alcohol. I don't think there's any states that are completely prohibited. That would be kind of rough. But I'm pretty darn sure that there's a lot of counties that are, because Kentucky is one of them. And there's others in the South that do the same thing. But you notice the common factor, and the factor is conservative religious groups go out and say, hey, we don't like alcohol because it makes people act like an ass. But it's the fact that it's a person. See, and that as lawyers, as behaviors that we are, police officers, we still got to worry about the behavior. How can we try to prevent it? By not letting people get drunk. Okay, but man, when they don't, can you totally eliminate, are you able to totally eliminate alcohol? If you're totally able to eliminate alcohol, then nobody's going to get drunk and there's going to be no problems. But that's not possible. We saw that with prohibition. It just became a black market. Same thing with guns. I mean, if you're not going to totally eliminate guns, so it's now going to be a black market, and now you have no control over it. And we learned that from prohibition. We learned that it's better to not completely ban it, but regulate time, place, and manner. And that way we have some control over it. And that's what you see is 1917, we created the 18th Amendment, prohibited manufacture, sale, and transportation of any alcohol. 1919, the Volstead Act provided enforcement procedures, created actually it was originally done by the FBI. We banned alcohol for a period of time. And it's really kind of interesting. The 21st Amendment repealed it in 1933, but we had already gone through the stock market crash in 1929, and we were still 4 years into it. And that period was pretty rough because we had really high crime rates and everything else because the economy was down to nothing. And we were banning alcohol and a lot of other things, because you notice at the other slides where all the drugs were starting to be banned. So we had all these things prohibited that became an underground market that was very lucrative because people want it. Think supply and demand. Supply and demand, there is no supply if the demand is there, so they're going to create the supply and money goes up. So that's where you see 1933 it went back, and you see a big change because some places didn't have any alcohol or something like that. And I mean, even here in Detroit, the Stroh's, you laugh, but it's true. The Stroh's Brewery actually started making ice cream because we had a brewery here in Detroit, and now actually Michigan has become very popular for their wines and their microbrews and things like that. We're getting back into that market. But you had to change industry. I mean, you were geared toward, I am going to sell alcohol, and all of a sudden it's constitutionally banned. Now what do? Many went out of business. Others went underground. Jack Daniels, Jim Beam, those guys. The Bushes sold other things out in the Midwest and Missouri, and then they were able to flourish. They were able to kind of stay underground and then replenish when it was over. Now, over time, we have changed our views on alcohol. So what we've done is we've controlled it in the sense of how much can be sold, You have to have liquor licenses to be sold, and that's what you're gonna see this slowly permeating into the marijuana market. We're gonna have marijuana. We do have um, marijuana regulations on how much you can manufacture, how much you can sell, how much you can possess for personal use. You're going to have all that stuff because that's what we do with alcohol. Technically, I can possess as much alcohol as I want, but I have to have a license to sell it. Even if you're a microbrew, you can manufacture up to a certain amount before and sell it to other people. But you have to have a license if you're going to sell more than a certain amount, things like that. Which leads us to the Dram Shop Acts. Basically, it's a strict liability on seller of intoxicating beverages. So what we did is we put all of the responsibility on the end market and said that, look, if you sell alcohol, anything that results from your sale of alcohol is on you. So if you sell alcohol to somebody and you knowingly let them leave when they're drunk and they get into a car accident, that's on you too, civilly, but not criminally, potentially criminally too, depending on the state. And so anybody who's worked in a bar, all the training you have to go through in order to be allowed to sell alcohol. That's part of it. That's part of the dram shop laws. We have put the responsibility, again, not on the individual who's drinking it, but we're trying to eliminate the problem, theoretically, by putting it on the person who's giving it to them. Like I can't give alcohol to someone under 21, things like that. And we put legal drinking ages. That's another regulation we put on alcohol. FBI crime reports, over 1 million people are arrested for drunk driving. 414,000 arrested for drunkenness, public drunkenness, I'm assuming. 320,000 were arrested for liquor law violations, and that's, it happens. It's just another crime that we're trying to control. Drunk driving, again, we did briefly talk about it last chapter. What we're trying to do, because of the safety aspect of it, is eliminate the driving fatalities, because typically the drunk drivers themselves are the ones that survive and everybody else gets hurt. So this is the biggest alcohol statute that you're going to encounter is drunk driving. And we've got the different tiers here in Michigan where, 0.08, we lowered it down to 0.08 because we have to have something tangible. And that's where people have an issue, because well, when I drink a beer an hour, I'm not drunk. Some people aren't. You can go through and not have the behavior associated with it, but we have to have something tangible because your behavior is subjective, and subjective behavior doesn't hold up in court. Because I've seen people get drunk on non-alcoholic beer, or they act like they're drunk because they don't know any different. So we have to put a quantifier on it, make it tangible. So 0.08 in Michigan, and I think most states have gone that low. It used to be 0.10. Now it's 0.08. And then we have the super drunk at 0.16 and the super duper drunk. That's not what's called, but it's, basically what it is, 0.24. And there's more, the severity of the punishment increases with the amount. Driving while intoxicated, driving under these are what these stand for. Driving, DWI is driving while intoxicated. DUI is driving under the influence. Driving while driving on blood alcohol level, and I don't even know what DWAB is. That one's not a Michigan one. We have DWI and DUI because we use driving under the influence as our catch-all, because it doesn't have to be alcohol. It can be anything that impairs your driving. And then underneath the lesser included offense in that is impaired driving, anything that impairs your ability to drive. And then driving under the influence is enough to cause you to do something. So worse. It's used to be a lesser included offense. Now they're pretty much the same. But it basically boils down to the fact that something has impaired your ability to operate a motor vehicle. Intoxication, the definition: a person who ingested enough substance to diminish their physical and mental capacity, and adversely affect their judgment ability to operate a motor vehicle. Doesn't matter. There's no set number. It's not like I can't have more than one beer. It's just what your body can metabolize. And that's why we have to quantify it to say if your blood alcohol content is 0.1 or 0.07, and if you're any of the listed substances that we have, narcotic, you name it, anything that can impair marijuana, we're getting that as an issue because people are saying, well, gosh darn it, it's legal. I can have it. You're right, but you can't operate a motor vehicle with it. Just like you can't operate a motor vehicle with alcohol in your system, or you can't operate a motor vehicle with, I don't know, painkillers. It says right on the side of the bottle, do not operate heavy machinery. A car is heavy machinery. So you're not to operate a motor vehicle with it, gosh darn it. Blood alcohol content, again, it's just determined by our determination to figure out how we're going to quantify it. Pretty standard across the country now is 0.08. There's a few of them that have lowered it below that, New York and Maine. Maine says any alcohol in your system, and that one's tough because like cough medicine has alcohol in it. There's a lot of substances that have alcohol in it that you wouldn't realize have alcohol in it. So we quantify the number. Now we do have zero tolerance for juveniles, for example. If you are under 21 and you're operating a motor vehicle, if you have any blood alcohol content, we can take your license permanently. So there's a, we do treat juveniles a little different. What does it take to get drunk driving or under the influence driving? You have to do something to indicate that the you were impaired. So it's a process. Now you can have that probable cause initially fairly simply. You watch them weaving in and out of traffic, going too slow, going too fast, just violating a simple traffic law. But the one that's the biggest that gets you the indication is weaving in and out of traffic and overcompensating. You start to go off the road and then you go off into the other lane. And that's usually how the accidents occur because people have no depth perception and the reaction time is terrible. So then you have to get you've got the probable cause to do the traffic stop. And then you have to have the secondary probable cause that there's something under the influence. Now, it helps when they can't maintain lane discipline. That usually gives you some indication that there's some impairment. But a simple traffic, like somebody speeding, for example, usually isn't enough probable cause to get to the point of, hey, they got to be impaired. Because many of us speed when we're not impaired. Now, some things you do see, though, are people who drive exceptionally slow or like they delay at a traffic light. The light turns green and you're like, oh, okay, that could be enough to get you rolling. And then you go through, and that's what this is: the arresting officer observation of erratic operation of vehicle or the behavior lead to this traffic stop. Officer then has to note some physical appearance of driver, whether they're intoxicated, slurred speech, slow reaction times. When you come out, you do a field sobriety test, which can include an astigmas test. It can include walking a line, saying your alphabet, all kinds of stuff. But slurred speech is another one, one of the ones that's pretty easy. Because if you say, license, registration, proof of insurance, and they say, here you go, Ossifer. Well, Ossifer tends to get carried over, and that might be enough to get you in the door. During the investigation, officer asks driver questions of their demeanor. If it looks suspicious, then you administer your field sobriety test. Like I said, walking the line, touching your nose, that type of stuff. Each state is a little different with their DUI statutes, but basically it comes down to a certain blood alcohol content, and you're going to get punished accordingly. There are also penalties for refusal. If you refuse to take field sobriety test, I can just immediately take your license, because having a driver's license is a privilege, not a right. So if I say I feel that I have probable cause to test you for impairment, and they go, well, I'm not going to do it. I'm like, well, I got your license, so I'm like, you're under arrest now. You're automatically under arrest at that point. They vary greatly. you can ask them if they want a blood test, but then they can do it consensually, or you can go back to the station and do, instead of a field sobriety test or a preliminary breath test, which is a little box, you can go back to the full breathalyzer, because that's, a lot of people get those two things confused. A field preliminary breath test is about the size of your cell phone. In fact, you can get the app for that now. There's an app for everything, right? You plug it in here and just, and it'll actually blow. And they did a study not too long ago. It was probably like last year's New Year's Eve things. They always do stuff about drunk driving. Last year's New Year's Eve, they wanted to compare those, the phone ones, to the ones you can buy over the counter, to the ones we use in the field, and they were all within 0.01 of each other. So that's actually pretty good for somebody, something you buy at a freaking Walgreens. And there's an app for that. Yes, you can do that. So it might not be a bad idea the next time you go to the bar to have the app for that. And I'm not going to leave until it's below 0.08. Voluntary intoxication is no defense, because of the mens rea involved with drunk driving. It can mitigate other crimes. So if I'm trying to commit murder or I'm killing somebody, I may not be able to form the mens rea to premeditate and deliberate, so alcohol can diminish it down to maybe a manslaughter. But for drunk driving, that's the point. So you're kind of stuck. It says alcoholics cannot be punished for their condition, but they can be punished for appearing in public while they're intoxicated. This is what I'm still confused about your textbook a little bit on that. I love your textbook. I will stick with this textbook for a while, but it talks about alcoholics cannot be punished for their condition, but they can be punished for appearing in public. So they're not being punished for being alcoholics. They're being punished for their behavior. And I think that's what you really got to remember. They're not being punished because they're alcoholics. They're drunk and disorderly. They're beating their wives. They're driving a car, whatever, open intoxicants, any of those. They're not being punished for being an alcoholic. They're being punished because they did something that violated the law. Forgive me, I feel like I want to sneeze. The Shermer case, blood was drawn while injured in the hospital after possible DUI. There's always a question, and this is a criminal procedure one. We'll talk about that much more in depth in criminal procedure, but to do a blood draw, they either have to consent or you have to have a warrant. You can't assume when somebody's unconscious that they're giving you consent for you to draw their blood. Now, if it was drawn as part of the normal process at the hospital, which often it is, you can get those results, but you can't order it without it. You have to have a warrant to get the fluids. Alcoholism is a disease and therefore could not be convicted of behavior that is compulsive as symptomatic of the disease, like public intoxication. I'm not sure where that was from, but I think that was a little iffy. Affirmed hinted for public intoxication, but does not extend to other crimes. So basically being out drunk in public, yeah, okay, we're good with that. But any other crime that you're drunk for, we're not going to let you slide. And we had a shift in, I think, mentality. 1966, we were trying to say that, because we were still in the rehabilitation phase. Take criminology with me. We're still in the rehab phase. So we're saying, it's a disease, da-da-da-da. Right, it is. But you, first of all, need to seek treatment, because the first step in any rehabilitation is acceptance and seeking the treatment. So we had that time frame where we were much more liberal with that stuff. And then it carried over, and we finally, in the 80s, war on drugs, all that stuff, we're like, look, we got to go back to still punishing behavior. You got to be accountable for your behavior, though. Yes, you have a problem, but you still can't keep using that as an excuse. You can't use that as an excuse for beating your wife, because that's kind of what was coming out of this is, I can't use that for my barroom fights every weekend. I can't use that for my beating up my wife, So we didn't want that dam to open up. So we said, okay, fine. Public intoxication, you're drunk and you're out in the public, okay, we're not going to allow that. So if you're not an alcoholic, you can get public intoxication charges. But if you're an alcoholic, hey, you got an out. I don't think it's fair, but hey, whatever. Just claim being an alcoholic, I guess. Otherwise, all the other stuff, it may mitigate it, but we're not going to be able to give you the excuse. And that my friends, is the end of drugs and alcohol. Not much else to say on that. We will potentially continue with the next stuff. So talk soon.